really glad to have you here. My name is Michael Cleveland. My colleagues here are Aaron Minook and Kayla Coburn, and we're all labor and employment lawyers. Oh, that's better, okay, at Miller Thomson. Aaron and I practice general labor and employment, and Kayla has a focus on education law. So, obviously with all the stuff that's in the news these days, Kayla isn't busy at all, I'm sure. So our session today, let me just advance this slide here. So we're focusing on recent statutory developments, both in Ontario and in the federally regulated environment. And there have been quite a few changes to employment-related legislation, as you know, in recent months. So in today's session, we're going to go over some of the most notable changes that are now in effect, as well as the changes on the horizon that might affect your organization. I'm going to speak about some of the key changes that have been made to provincial legislation in Ontario, so amendments to the Employment Standards Act and to the Occupational Health and Safety Act. And I'll also talk a bit about a new piece of legislation that has been introduced but is not yet law, and that pertains to regulation of the gig economy. Finally, I will touch upon some additional amendments to the Employment Standards Act governing the regulation of temporary help agencies and recruiters. And this will be of significance whether you are a temporary help agency or a recruiter, or you use the services of those businesses. Kayla is going to touch on two big mandatory policy developments in Ontario that likely, they made the rounds in the news, but these are the right to disconnect and the electronic monitoring policy. So Kayla's going to talk about some of the best practices involved with prepping those policies. And then Aaron is going to touch on the federally regulated sector for all our federally regulated clients in the room. She's going to talk about pending amendments to the Canada Labour Code, as well as changes to the rules at the Human Rights Commission. All right, so do I need this mic, or can people hear me when I'm... Okay, perfect. Thank you. So in terms of for some context here, late last year and early this year, there was a real flurry of activity related to employment law, kind of in the run-up to the elections this summer. And the government passed two bills, one in December 2021 and one in April 2022. Decided to name both of them the Working for Workers Act, so not confusing at all. The first act, which was implemented last year, it's been around for a while, so I will just kind of run through at a high level the changes that were made as a product of that act. So the big ones were a prohibition on non-competition clauses in employment agreements. This was implemented on a go-forward basis, so any non-competition clauses in employment agreements after October 25th, 2021. There are limited exemptions for C-suite executives or individuals who effectively sell their own business and stay on as an employee of the purchaser. And a question that comes up a fair bit is, if I have an employee who signed a non-competition clause before October 25th, 2021, can I still rely on that non-competition clause, or is that invalidated by the statute? And the case law that has come out since indicates that the statute only operates from October 25th forward. So there's not it won't retroactively invalidate. You may have difficulty enforcing it on other grounds, on our principles that it might be overbroad or ambiguous, but the statutory bar itself only is in effect from October 25th forward. Another change, there were kind of a slew of smaller changes. One is sort of an interesting one tying into the gig economy, which is a topic we'll get into in a moment, but it's a requirement that if you are a business that has couriers attending your premises, there's a requirement to allow those couriers or delivery persons to use the washroom on your premises. And the two really large changes that kind of warranted a separate section in this presentation are the intention of the government to start regulating temporary help agencies and recruiters, as well as the introduction of the requirement to develop a right to disconnect policy. So Kayla's going to touch on that. What I will do is I'll just run through some of the 2022 changes, and then we'll turn it over to Kayla for a look at those policies. So hot on the heels of that 2021 act, we then got a second act earlier this year, which again dove into making some amendments both to the ESA and to the Occupational Health and Safety Act. So the first big change is an exclusion for certain categories of workers from the ESA, and this is this exclusion for business consultants and IT consultants. The change is scheduled to take effect on January 1st, 2023, and there are some specific conditions to the exclusion which are worth being aware of, but it is helpful in the sense that this will clarify there can be this whole debate over when individuals are employees versus independent contractors is something that comes up quite a bit. So it is helpful in the sense that the government has taken some steps to clarify when an individual can be engaged as a contractor and not subject to those ESA requirements. So essentially, we have this definition of business consultant, which is described as an individual who provides advice or service to a business or organization in respect of its performance. And this includes things like providing advice on its operations or profitability, providing financial or human resources services. And then similarly, the IT consultant provision is an individual who provides advice or services to a business or organization in respect of IT systems. So this could be security, testing, designing or documenting various aspects of the business's IT system. So it's not only a situation where they simply provide those services, there are additional requirements to qualify for this exemption. The biggest really being that you can't just hire an individual person to provide those services and then classify them as a business or IT consultant. They need to be in an agreement. Basically, the company needs to be in agreement with a corporation in which that consultant is a director or a shareholder, or the consultant needs to be providing their services through a sole proprietorship with a name that's a business name and operating under a business name that's registered under the Business Names Act. There's also a wage requirement that has to be met in order for this exclusion to apply, and what it is unless the consultant is being paid $60 an hour or more, then the exclusion won't apply. So it's sort of setting out this fairly high threshold at which an individual may be excluded from the application of the ESA, and that figure is exclusive of things like bonuses or benefits. What we would be focusing on in determining whether that exclusion applies is whether the effective hourly wage of that person is $60 an hour or more. The next piece I will touch on is the requirement to provide naloxone kits in workplaces. Now, this is a provision that has not yet taken effect. So the bill has been passed, and the amendments are poised to come into force in the Occupational Health and Safety Act, but we're still waiting on the specifics of this provision, and including which workplaces will be required to have naloxone kits. But the gist of it is if a employer is aware or ought to be aware that there's a risk of an employee having an opioid overdose in the workplace, then they need to stock a naloxone kit. In addition to stocking it, they need to maintain it in good condition, and they need to provide adequate training in accordance with the amendment. So the training essentially requires that at all times there's a worker who is in charge of the naloxone kit, works in the vicinity of it, knows how to administer it, is aware of the risks and the hazards associated with using it. So again, somewhat akin to existing requirements around the presence of first aid kits in the workplace, but adding it on, and this isn't a blanket requirement for all workplaces, it's specifically when there is knowledge or someone should reasonably know that there's a risk in the workplace. So the government hasn't published the legislations which will provide a bit more insight into which workplaces or which categories of workplaces will need to have these kits. They did indicate in some press releases that they expect that, for example, the construction industry will be one area that will be required to stock those kits, but we're on standby waiting for some further details on that front. The next change that's notable is this a series of changes to the Occupational Health and Safety Act to fairly significantly increase the penalties for noncompliance with the Act. In the run-up to implementing this legislation, the government really expressed a desire to help build worker protections by focusing on and holding employers responsible for not complying with health and safety laws, and in particular, as we'll see, focusing on the role that directors and officers have to play in ensuring compliance with the Act. So the big changes here are the Occupational Health and Safety Act has been amended to increase the maximum fine for contraventions of the Act from $100,000 previously to $500,000 for individuals. The amendments also provide for a maximum fine of $1.5 million or imprisonment for up to 12 months, or both of those, for directors or officers of a corporation who fail to take reasonable care to ensure that the corporation complies with the Occupational Health and Safety Act. This fine, as significant as it is, it can also be applied on a sort of per offense basis. So if you have a situation where there are multiple offenses, you're looking at fairly significant fines. And in addition to these enhanced fines, there's now a section of the Occupational Health and Safety Act that sets out a series of aggravating factors related to a prosecution that may increase the potential for a judgment at the higher end of that range. So these are things like an element of moral blameworthiness in the defendant's conduct, attempts to suppress or obstruct the investigation, or a finding that the defendant was motivated by a desire to increase profits or minimize costs. In addition, courts will be allowed to make any other prescribed orders that, in addition to this sort of $1.5 million or 12-month imprisonment provision. And in terms of a limitations period, the limitations period for commencing prosecutions has been increased from 1 year to 2 years. I'm going to turn it over to Kayla now to chat about the electronic monitoring policy requirement that was introduced through this legislation.
Perfect. So I'm not sure if this will be new to many people, since I think it's gotten a fair bit of media attention, but still important to review nonetheless, because it is a pretty recent thing still. So with the pandemic, we've seen the am I loud enough? Sorry. We've seen the rise of remote and hybrid work, and this new work culture has brought about some concerns by employers surrounding how they will ensure that their people are working, if they're working more or less, or the same, or at all. And so some employers have chosen to rely on surveillance software to monitor their employees and track the kind of work they're doing. But up until now, they've had no obligation to inform their employees that they're engaging in these kinds of monitoring activities, and so employees have been oblivious to the fact largely. So as of October 11th this year, Ontario employers with 25 or more employees must have a written policy on electronic monitoring in place under Bill 88. So the legislative intent behind this requirement is to provide greater transparency to employees about their employers' electronic monitoring practices. And accordingly, there are no new changes or restrictions. Oh, thank you. I am quite loud, but This helps. There's no new restrictions about the scope of an employer's ability to electronically monitor their employees. So there's not much new in that regard, that it doesn't restrict your ability to do it. You just need to tell your employees that you're doing it, basically.
In order to get it on the recording, it's just signaling that the mic has to be.
Oh, okay. Sorry about that. Just apparently I need to be closer for the recording. Is that good? Bring it closer. That good? Okay. All right, so, and for greater clarity, this applies to both management and executives. So it applies to all your employees. And electronic monitoring includes all forms of employee and assignment employee monitoring that is done electronically. So some examples of what that might include could include using GPS to track the movement of your employee's delivery vehicle. It could include using an electronic sensor to track how your employees are scanning items at a grocery store. It could also be tracking just the websites that your employees are visiting during working hours. So to reiterate, that will apply to employers with 25 or more employees as of January 1st of a given year. And that's what the threshold will be if you need that policy, if on January 1st you have at least 25 employees. And a copy of that policy must be provided to those employees, of course. And so compared to the right to disconnect policy piece that I'll be discussing in a bit, it's a little less flexible what can go in this piece because you are obligated to disclose if you're engaged in that kind of monitoring. But it isn't creating new privacy rights for employees, if that's a concern. And what does have to go into these policies, however, is whether you are engaged in that kind of monitoring of employees. And if you are, a description of how and in what circumstances an employer may be electronically monitoring the employees, and the purposes for which that information that's been obtained may be used by the employer. And the second piece, of course, will be that the date that that policy was prepared and the date of any changes to that policy. But that shouldn't be surprising, I don't think. Now, there are also some specific deadlines for distributing this policy to employees. Specifically, copies must be distributed to employees within 30 days of either adoption of the policy, any revisions to the policy, and within 30 days of a new employee being hired. Assignment employees must also be given a copy of the policy within 24 hours of assignment. So employers are not prohibited from monitoring their employees, but you must disclose it now. And failure to do so could cause some disgruntled employees to launch complaints, so it's incumbent upon you, of course, to make those policies happen. And so in terms of timing, though, even though we are a little, these policies should be in place already, just so for everyone's clear, that if you have 25 or more employees as of January 1st of this year, you had until October 11th of this year to have that written policy in place.
Okay, thank you, Kayla. I'm going to touch on a few additional pieces of legislation and amendments that deal with this sort of in the context of work that isn't simply permanent employment with one employer. So I'm going to touch on this Digital Platform Workers' Rights Act, which is meant to some extent regulate the gig economy. And then after that, I'm going to go into these provisions that these amendments to the ESA that look to regulate and license temporary help agencies and recruiters, and imposes obligations upon those who use those services. So to start off with the Digital Platform Workers' Rights Act, this is an interesting piece of legislation that was introduced alongside or through the Working for Workers Act 2022, and it ties into what is really an emerging and interesting area of law, which is this question of, are the workers who, say, deliver for Uber or skip the dishes, are they employees? Are they independent contractors? Are they some kind of in-between category? And this has pretty significant implications for whether they, how their employment relationship is structured, what are their entitlements under the ESA, are they entitled to unionize? And even if you're not directly in the space, if your organization doesn't provide these services, I do think it's an interesting area to be aware of, because this sort of contingent work and gig work is, moving into different sectors of the economy, and it's interesting to see how the government is thinking about regulating it. So the government, by introducing this act, they are, at least their stated goal is to improve conditions for gig workers, and also to just set out some basic guidelines for the conduct of the operators of these digital platforms. So what the act has a fairly narrow application, and it applies to workers and businesses who are engaged in providing rideshare, delivery, courier services by workers who are assigned on a sort of task basis or case-by-case basis. The act really functions to provide some basic, what we might think of as employment protections, but obviously not treating these workers as employees specifically. But it does set out things like requiring a basic regular pay period, pay statements, and an explanation of any deductions and amounts earned during a pay period. In addition, there's a requirement that these workers be paid at least the minimum wage set out in the ESA. Although an interesting caveat to that is that the requirement is only in effect when the worker is actively performing those services. And I think the wrinkle there is that when you have folks who are delivering for or driving for Uber, they spend some of their time active, but some of their time waiting for jobs, and the minimum wage requirement only applies to the active time. So they may, in effect, not always be earning that minimum wage on an hour-by-hour basis. The other pieces of the Act that are of note is that the Act prohibits an operator from removing a worker from the platform without providing a written set of reasons as to why that removal occurred. And there's also a notice requirement if the removal is going to be for more than 24 hours, they have to provide 2 weeks notice. So obviously this isn't anything akin to a termination protection per se, but it is, there's some element of requiring the platforms to provide notice to those workers of why they were removed from the platform. There's also a requirement that all disputes under the Act need to be resolved in Ontario. I think this is likely a reference to a case that some of you may have heard about. This was Heller versus Uber. This is one of those cases that went to the Supreme Court in 2020 or in 2021. And this was a case that dealt with where Uber had an arbitration clause in their agreements with drivers that basically required arbitration to occur in the Netherlands. So, which can be an onerous undertaking for someone who is driving for Uber. So in that circumstance, I think this act is, at least the way we read it, I think is maybe trying to address that and saying that disputes under this need to be, addressed in Ontario. The Act includes compliance and enforcement provisions that are fairly similar to the provisions of enforcement that are under the ESA. So general contraventions of the Act can result in fines of $50,000 to an individual or $100,000 on a corporation's first offense, scaling up to $500,000 for subsequent offenses. Orders can be made to repay outstanding amounts, reinstate access to the platform, and to compensate employees for losses arising from the contravention of the Act. An interesting thing to note is that this Act doesn't create a sort of middle category of gig worker or platform worker. These workers aren't carved out of the ESA, and there's nothing express in the legislation that says that someone who is a platform worker can't also be an employee. So we'll have to see how this plays out. I'm aware of at least one employment standards decision where an Uber driver was found to be a employee. Not sure, I think that's in the process of being appealed, but I'm not sure what the status of that is. But it is sort of, I think, an area that we will see develop more in the coming months. This legislation isn't in force yet. The government has implemented a committee to examine both this legislation and how to implement it, along with the prospect of implementing what it's calling a portable benefits package, which is this idea that when you have these categories of platform workers or temporary help agency workers who are moving from assignment to assignment or from employer to employer, they're exploring this idea of attaching a benefits plan to the employee rather than it being provided through each employer. So these are all in very early stages of development, I would say, but it is because it's becoming an increasingly significant part of the economy in Ontario. I think it's an area to watch for sure. And so I'll flip over to talking about the other side of this, which is temporary help agencies and how they are regulated. This was originally introduced on the 2021 Working for Workers Act, and it was this idea that the government moving forward would begin to require licenses for temporary help agencies and recruiters to operate. For background, there are over 2,000 temporary help agencies in Ontario and over 128,000 employees who perform work for temporary help agencies. So again, not an insignificant sector of the economy. And of course, this legislation is relevant to anyone who uses those services, not simply the employees of those agencies. So important to note that these licensing requirements are not in force, and we expect it should be some time before they do come into force. The government is in the process of developing the regulations surrounding the licensing regime, and they've indicated that they don't expect them to come into place until 2024. But it's good to be aware of what's on the horizon, and we expect that because there are going to be obligations placed upon the users of these agencies, you want to make sure that you're ready to comply when the time comes. So the crux of it is that all temporary help agencies and recruiters operating in Ontario would require a license in order to operate. They would essentially be vetted before being issued a license, and they would need to provide things like an irrevocable letter of credit that could be used to repay any wages that were found to be owing to workers. Important for users of these agencies or recruiters is that persons will be prohibited from using unlicensed services in this regard. So there's a prohibition on using an unlicensed temporary help agency or on an unlicensed recruiter. So there'll be an obligation to ensure that the services that you're using are licensed. The government will have the authority to issue or revoke licenses if they believe that the agency or the recruiter hasn't complied with the law or doesn't intend to comply with the law or has been misleading in their application for a permit. The penalties that could be issued, they could be issued against unlicensed agencies that are operating, as well as the companies that use them. And the legislation does contemplate the use of inspection measures to enforce compliance. Now, the final topic that I'll talk about today is just a quick update on the status of COVID-19 leaves, both in the provincial and federal realms. So in provincially regulated workplaces, the unpaid infectious disease emergency leave that we've had for the bulk of the pandemic here at this point is still available. And this is because COVID-19 remains a designated infectious disease under the ESA regulations. Until those regulations are amended, employees can still take an unpaid infectious disease emergency leave if they are, for a set of reasons, so isolating for COVID-19, if they are under a medical investigation, or if they're providing care or support to a family member because of a matter related to COVID-19. Now, there's the other element of this infectious disease emergency leave is the paid entitlement, that 3-day paid entitlement. And note that that's a total entitlement for essentially the duration of the pandemic to date. It's not a sort of yearly entitlement the way that most other leaves are contemplated, where every calendar year you get a new set of entitlements. This is 3 days since the beginning of paid idle being introduced. The key thing here is that this is going to expire. It's been pushed back a dozen times now. So, we've we've had these expected expiry dates that have never come to fruition, but the government has indicated that, okay, they intend to allow it to expire on March 23rd, 2023. And just a quick background on it is that employers, until that date, employees can be entitled to take the paid leave, mostly for the same reasons as they are entitled to take the unpaid infectious disease emergency leave, but a few of the requirements are a little narrower than for unpaid infectious disease. So some of the provisions around when you're providing care for a family member is a little bit narrower, so they have to actually, I think, be under medical investigation or similar in order for the employee to be entitled to that leave. Now, the one that is no longer in effect is this deemed infectious disease emergency leave, and this saw a lot of use at the start of the pandemic when individuals, when there were reduced or business closures, and individuals had to be, held out of work for a period of time. This essentially allowed for when a reduction of work or hours occurred, it was deemed not to be a constructive dismissal or a temporary layoff under the ESA. That expired in July, so now any temporary reduction in hours of work or removal of hours of work would be governed by the temporary layoff provisions in the ESA. Federal is a lot simpler. The COVID leaves have expired. There's not really anything there at the moment providing for a COVID-related leave in particular, but employees would still, of course, if they're ill, may still have access to personal leave and medical leave in accordance with the existing rules. Thank you, and I will turn it back to Kayla for another policy piece.
Another policy piece. It does feel like a show.
Yeah.
Especially with it. All right. So another piece that I'm sure we're familiar with because it's been covered a lot in the media. Oh, let's prevent this again. So with Bill 27, another one of the Working for Workers Act that received a royal assent late last year, we saw another new policy change requirement come to Ontario employers of 25 or more employees again, and that is that you have to adopt a policy regarding disconnecting from work. So the Ontario legislature has defined disconnecting from work as the following. Disconnecting from work means not engaging in work-related communications, including emails, telephone calls, video calls, or the sending or reviewing of other messages so as to be free from the performance of work. Now, in terms of how this policy plays out in practice for you and how it applies, this policy will apply to all employees. It will apply to both management and executives, for clarity. It will apply to all employees covered by the ESA, as well as any other groups of employees who might otherwise be subject to exemption categories under the ESA. That said, an employer can have a single policy that applies to all employees, or you can even have multiple policies, either in a single document or a couple documents, for different groups or kinds of employees. You don't have to just have one for every kind of employee. For example, since managerial employees are generally exempt from hours of work rules under the ESA, they may have greater obligations to respond to after-hours communications than non-managerial employees. So it's completely fine to have a policy or multiple policies that distinguish between different types of employees who may have different responsibilities to engage in after-work communication and calls, emails, depends on your work environment. But any differential treatment must still respect the ESA rules, of course. So what has to go into this policy? This one's quite flexible, as is the other one, but this one more so, I think. But in developing your disconnecting from work policies, you do have to have two key things, essentially. One, you have to include the date the policy was prepared, and two, the date any changes were made to that policy. The rest is up to you. So, other than those requirements, the ESA doesn't specify the information that the employer has to include, nor does it specify a particular link for the policy. So the Ministry of Labor has put out a guide for this, though, and they've just emphasized that the employer determines the content of the policy. So the ball's in your court for that. So in other words, there's generally a lot of flexibility to what employers can put in place for their disconnecting from work policy, as long as it abides by the ESA. I'll set out some examples for what your policy may address, if that helps, that the guide has also provided us. So one may be your expectations with respect to reading or replying to work-related emails or answering work-related calls after a shift or after working hours. Another example may be setting out expectations regarding communication and availability for different kinds of situations. So for example, the policy may establish a different response time for communications depending on the time of day that the communication is received and depending on who is contacting the employee and the like as well, with those kinds of details considered. And lastly, the employer's requirements for employees for turning on their out-of-office notifications might be something you cover, and changing your voicemail message, and when they are not scheduled to work, that you want them to update that, of course, to communicate that they will not be responding until the particular day that they're in next or working next. So setting out some perhaps additional considerations you might want to think about as well. Your policy, of course, must take into account the existing limitations and restrictions under the ESA regarding employee working time, including but not limited to those dealing with hours of work, rest periods, and breaks for non-exempt employees. From the perspective of existing ESA hours of work standards, any disconnecting from work policy for employees who are not subject to an exemption, at a minimum, might prohibit communications during minimum rest periods and after maximum working hours have been reached for a given day. A disconnecting from work policy should also address flexible and remote work directly, since that's the new environment we are in, right? And explain how an employee's ability to disconnect will still be respected, even if they are required to be available outside nor a standard 8-hour day. In particular, employers should probably ensure that all working hours are tracked and compensated and that minimum rest periods are provided for. And lastly, although it's not required, it may be helpful in some circumstances to choose to include a provision that the disconnecting from work policy gives employees the right not to perform work when the rules of the ESA may otherwise allow it, which is still going to be enforceable under the ESA, but that might depend on your work environment and your industry. So once you do have your policy in place, which, as we'd like to stress, is going to really depend on your environment and your employees, because there aren't too many requirements. It's the content's up in your court. But you do have to provide a copy of that written policy, of course. You have to provide that written policy within 30 calendar days of the policy being prepared, of the policy being changed, if an existing policy was changed, of course. And the employer does not need to provide a copy of that written policy annually if the policy has not changed from the previous year. The employer must also provide a copy of that written policy to all new employees within 30 days of that new employee being hired. So the policy can be, this is guidance from the ministry, the policy can be printed and provided to them. It can be in an attachment to an email, or a link to the document can be provided as long as the employee has access to the document and a printer, really. And then for your record-keeping requirements, employers must retain a copy of their policy, of course, for 3 years after the policy may or may not be no longer in effect. And then some further maybe practical parting notes to think about with this are that, Ontario employers, you're required to have this policy, you were required to have it in place by June 2nd of this year, actually. But starting next year, you need to have it in place as of March 1st if you have more than 25 employees. And some other things to think about when you're developing these policies are the benefits of them, really, and that's what the intention was, I think, behind the legislature bringing this in, which are that it has been proven that limiting working time generally plays a significant role in employees' mental health. And disconnecting from work policy could be an opportunity to actually revisit workloads for your employees. It could lessen the chance that you have a small group of employees who are always the ones electing to do after-hours work. And you could revisit those workloads and redistribute so that you lessen the chance that after-hours work has to happen at all, maybe. And lastly, you might also take the opportunity to revisit your workplace communication infrastructure. That could be reevaluated to implement software that allows for employees to restrict their work-related communication so they can be more mindful of what's coming in and what they're putting out. And it can also be a means of tracking and limiting their hours of work. Oh, sorry. Missed that slide.
Oh, okay, it's on, and I will move it a bit closer. Just out of curiosity, how many federally regulated employers do we have in the room? Okay, the rest of you will just use this as, a tidbit for a cocktail party or something, a couple fun facts, just, little punchy lines here and there. So what I'm going to be talking about today are some changes that happened in the Canada Labour Code. And the first one I'm going to talk about is the harassment and violence prevention regulations that were put in place. They were actually put in place in January, became effective in January 1st, 2021. But I think it's relevant to talk about now, first of all, because, we haven't had a chance to do a seminar like this in a long time, but also as people start to come back into work, these incidents of harassment and violence can also be more prevalent, and there might, new situations might arise that weren't at issue in January 2021. It feels like 100 years ago at this point. And so when I was looking into the background of this bill, Bill C-65, which pretty much revamped the workplace harassment and violence for the federal industry, they actually did a lot of research, and I think they were obviously getting a lot of pressure to make more robust investigative regime for federally regulated employers. And so actually when I was looking, they actually did a lot of surveys with Canadian public to see what they wanted to see from the federal industry in terms of workplace harassment and violence. And so as you see here, these are the three kind of pillars that they based these changes on for the Canada Labour Code. So the first is prevention, and I think this comes from creating a culture that's supportive and addresses, harassment and violence, making clear that, there are clear reporting mechanisms, and then, of course, the response is making sure that, of course, things are kept confidential, people know where to go when things happen, and then supporting affected employees after and throughout the process. And so the notable changes in this legislation, I think what actually frames the entire change to the legislation is the change to the definition. What I found interesting is that in the prior regulation, it actually only defined violence. So if there was an allegation or a complaint of harassment, it was actually up to the employer at the time to decide whether that harassment met the definition of violence. So that's very tricky, and so what they did now with this new regime is they redefined it to be harassment and violence. So as you can see here, it says any action, conduct, or comment, including of a sexual nature, that can reasonably be expected to cause offense, humiliation, or other physical or psychological injury or illness to an employee. And so I think what's really interesting here is it's not just the physical aspect that's mentioned, but it's also psychological. And I think that's important because, as we all know, harassment does not always come, it's not physical, it can be verbal, it can be inferred. So I think that entire definition really frames how the federal government decided to implement these new changes. And so even as maybe a provincial regulated employer, which it seems like a lot of you are familiar probably with workplace assessments and doing them for violence, and just to kind of get a sense of your workplace and say, okay, where are the risks? What can we do to help those and keep our employees safe? And so what they did with these changes to to the Canada Labor Code is they said, okay, you have to conduct workplace assessments, but the risk factors that you have to consider in doing these assessments are actually internal and external. And so I'm actually going to read a few of the risk factors that they want you to identify. And so they get you to look at the culture, conditions, activities, and organizational structure of the workplace, circumstances external to the workplace, such as family violence that could give rise to harassment and violence in the workplace, any reports, records, and data that are related to harassment and violence in the workplace, the physical design of the workplace, and the measures that are in place to protect psychological health and safety in the workplace. So I think all these changes to the workplace assessment and how that's done is you can see there's a clear recognition that it's not just about violence. There can be things going on with employees at home that can affect, risks to other employees in the workplace. And in general, with these workplace assessments, this is the time where employers will work with their health and safety representatives or workplace committees to actually to see how those assessments are and identify those risks. And so the other point is you also want to, in the Canada Labor Code, in these amendments, they just kind of ran through the prevention policy that you should have in place, kind of just enforcing and more strict measures about the investigation, how it should go, how responsive you should be to your employees when you are conducting some sort of investigation. And it's actually interesting. One thing that did change about the investigation is that now it's on the employer. It used to be on the Health and Safety Committee or the representative, but actually now it's on the employer. And I think that's kind of what the amendments are getting at, is that this is an employer responsibility. It's not, you can't just, give these responsibilities to some sort of committee. It's on the employer, and you're gonna unfortunately bear the consequences of anything that goes wrong. Otherwise, there are new record-keeping requirements under these regulations. You actually have to keep any sort of workplace violence and harassment records for 10 years. And as well, there is now extended training requirements. So all employees, regardless of their leadership position, have to be trained. And they emphasize in these amendments that the content should be, it's not just, here are a couple slides, we'll use them for, the next 10 years. They really want it to be specific to the workplace that you're in. And I think this training can be influenced by the workplace assessment that you do, by identifying these risks and saying, okay, how are we going to mitigate them? And actually, including that into your training and saying, this is what we want to look for. These are risks that we've noticed in the past. And that will come with, unfortunately, certain complaints, but also just kind of hearing more about from the workforce where those risks are going to occur and how we can mitigate them. And so that is all in terms of the Canada Labor Code changes in terms of harassment and violence. But I'm going to turn now hot off the press. This is new. This is very exciting. We just found out about this on October 28th. So when we're talking about news, this is it. And so these are some changes, again, for federally regulated employers, some updates to the Canadian Human Rights Commission rules. So we got notified on October 28th that there are some updates to the rules, and these updates that I will outline, they apply to all complaints received after October 19, 2022, but it also applies to any complaints entering the next stage in the Commission's complaint process. And there are a bunch of different stages, so really this is applicable to a lot of ongoing cases at the Canadian Human Rights Commission. And so I think what seems to be driving these changes, and there's not that many, is that the Canadian Human Rights Commission really wants to make the rules more inclusive. And so this is most identified in the rules with some new definitions. And actually one of the new definitions that they include is dead name, which is a term that's used by two-spirit, transgender, or gender diverse individuals to refer to their former name that's no longer used. And so as you'll see, if you ever look at the rules, a lot of the changes are actually in recognition for individuals' preferred pronouns and ensuring that when you're filing a complaint or you are responding to a claim is that you're actually really mindful of that and you're only using the pronouns that that individual says that they want to be addressed by. A lot of the other changes, there's a couple procedural changes. Another definition that's actually defined is, so you used to be able to apply for an extension of a response or a reply in exceptional circumstances it would be granted, but that exceptional circumstance was never defined. So now it's much more clear. So exceptional circumstances is something that's unavoidable or unforeseen. So it still feels pretty exceptional in general, but I guess they're giving a little more context now. And before in the previous rules, if you were responding to a complaint at the commission, you would have 30 days to file a reply, whereas now you have 60 days, so a little more time to kind of gather your thoughts and consult with legal counsel and propose the best response. And also, too, one thing that seemed to be apparent is maybe this is just by nature of not getting great documentation. The commission's a little fed up, but they seemed to really say that when you are submitting documents to the commission, that they have to be relevant, otherwise they will not be considered. So I think they just reiterated that just to kind of drive that home. And in terms of formatting documents, this also goes back to the pronoun issue that, if there is a complainant or an individual that is requesting personal pronouns be used, then if those pronouns are not used, then, there will be consequences for that party, and that's considered, the proper format is also the pronouns that they choose. And another section that they added a few different things on the commission is this idea of respectful conduct. And again, this is really about the pronouns, the way that they're used, and also, and two, as much as it puts pressure on the complainant and the response to abide by these pronouns, it's also for the commission, which I think is a really good recognition for them that that's also on them. If you're at a hearing, to address people by their preferred pronouns, which is very important, and it makes people feel it's a respectable thing to do. It is, and so. I think also, too, what another thing they did to enforce this respectful conduct is that if in a complaint, it doesn't matter if it's what the ground of the allegation is that if you have to refer to the former name of an individual, you actually now have to redact it. You can't put that in there, and you can put a cover letter on your response or on your complaint and just say, in accordance with the rules, this is why we have redacted the name out of respect for the individual, which I think is a really great thing that the commission has implemented. So those are the some highlights of the federal industry that's come to light lately, but I believe that makes us come to our conclusion, and I want to see if you guys have any questions or anything else.
If not, or just giving you a few moments to think about questions. I think I would be remiss to not point out the hot off the press again bills that have come out this week for the education sector. Last I checked, I don't believe we have any education sector clients in this room, but in case that's changed and you're still interested, Nadia, Jillian, and I, and Renata and the education group, we're following the developments intensely, closely. I'm sure there are even some going on right now, but Bill 28, basically keeping kids in class, was tabled on October 31st, so that was Monday. That's why it wasn't in our presentation. We had to have slides ready beforehand. And what to say about that? From a legal point of view, what is that bill doing? It's imposing a collective agreement on CUPE, essentially. It's also invoked the notwithstanding clause, so it's doing so notwithstanding the rights and protections that those workers are afforded under the Charter and the Human Rights Code. And it's also imposing some really heavy fines for any contravention of that, which is basically prohibiting strikes and lockouts. So that's never a dull moment, for sure.
Doesn't look like we have
Yeah.
any questions, but
We will stay here if anyone wants to come up.
be hanging
privately as
around
well.
if anyone wants to chat. And thank you so much
Yeah,
again
thank
for
you.
attending. We do appreciate it.
Thank you.
Oh, thanks.